unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, welcome to the show. Today we're talking about resolving title issues regarding adverse possession. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like and subscribe to the channel. You can find us on YouTube, you can find us on Facebook, and you can find us on Twitter. We are at InRem Podcast. That is at InRem Podcast. With that, I'm going to turn it over to Sean, who has our legal update.
Thank you, Andy. So my legal update today is going to be a little different than what I've been doing the last few weeks, which is the what if questions. But instead, I'm going to talk a little bit about a law that was just passed in the state of Alabama. It's Act number 2023-201. It goes into effect August 1st. So, about a week from now, it'll be in effect. And it did two things. I'm only going to talk about one today, and then I'll talk on our next show about the other item that was addressed by the law. But this item, we actually have talked about it on the show with Tina Tambor. About a year ago, she came and we were talking about this thing that's going on with real estate and a couple of, at least one real estate brokerage, licensed broker here in Arizona and other states, where they're basically going and approaching homeowners and saying, hey, homeowner, how about signing a long-term listing with us? In this case, it was like a 40-year listing, and we'll pay you X amount of dollars right now. But if you ever go sell your house, you have to list it with us. And if you don't list it with us, you still have to pay us. And so they then they have the homeowner sign a listing agreement, and they record the listing agreement. So it's a cloud on the title. And the listing agreement says runs with the land. So even if the homeowner sold, it would basically act as a lien against the property for future homeowners. And a lot of unsuspecting homeowners were basically getting sideways with this thing, right? I mean, they signed it maybe 4 or 5 years ago. They go to sell their property, and all of a sudden they realize, oh shoot, we have a problem. We've already listed it with this other agent. Now we're in escrow, and oh yeah, we signed this other listing agreement or this other document, and we have to pay this other company a bunch of money. And it's, significant sums, tens of thousands of dollars that are required to be paid. And it's a cloud on title, and so negotiations have to take place with this real estate, brokerage and the whole thing. So a number of states, their attorney generals have become involved, and they filed lawsuits, and those lawsuits are pending. Well, the state of Alabama has followed some other states here, including Colorado, Georgia, Tennessee, Idaho, Maryland, North Dakota, and Utah, in actually passing legislation. And so Alabama's the most recent to pass this legislation. And basically what they've said in this legislation is, any agreement after August 1st to this effect is going to be considered an unfair and invalid agreement, and will subject whoever benefits, the real estate company that benefits from it, to civil penalties of $10,000 plus attorney's fees and the whole thing. So the fall under the provisions of the statute, the agreement has to contain three things. First, it has to deal with the providing of services in connection with the purchase or sale of residential real estate. It has to, the agreement has to last for longer than 1 year. And it has to either, and there's three options or alternatives here. It either purports to run with the land and be binding on future owners of the property, or it allows for the assignment of the agreement um, uh, without any notice to the owner of the property. So if the real estate company wants to assign it, if it has that clause, it's going to be problematic. Or finally, it purports to create a lien, encumbrance, or other real property security interest. So basically deals with the providing of services for the purchase or sale of real estate, lasts longer than 1 year, and either purports to run with the land, allows for the assignment, or purports to create a lien, encumbrance, or other real property security interest. So if the agreement falls within that category, it's going to be considered an unfair agreement and in violation of Alabama law and basically unenforceable. So the question is what about all these homeowners over the last however many years that have signed these agreements, but prior to August 1 of 2023?
Right. It only deals with everything after the law's passed,
Correct.
right?
You're right. And so unfortunately, the law does not go and just, blanket invalidate all of these prior agreements. And so those prior agreements are going to have to involve, some form of litigation as to whether or not they're going to be enforceable under the statutes that were in effect at the time the agreement was entered into. And so unfortunately, those are still there and are going to have to be, dealt with on a case-by-case basis. Now, one of the things that the law did that's important to note is it also, to make sure that certain things didn't get swept up into the law.
I was just going to ask, a lot of times there's a rush to judgment,
Right.
and you get a vague and ambiguous law that grabs onto a lot
Yes.
more than we thought. And what I was thinking is, have you seen anything like that in this one?
Right. So they've done their best to try to accept out certain types of transactions. So of note would be options to purchase and rights of first refusal on real estate. Those are going to be accepted out. So even if they have maybe arguably some of these provisions that, would cause it to fall under the law, if it is truly an option to purchase or a right of first refusal as to the real estate, it's going to be accepted out. Also, fixture filings. So security agreements where personal property is going to be affixed to the land, such as solar panels would be a good example.
Sure.
That's not going to be prohibitive. And even if arguably the provisions of the security agreement or the solar panel purchase agreement or loan agreement would provide that it might potentially, it's still going to be accepted out. So they were very clear to accept out these, types of specific things. Listing agreements could still be longer than 1 year, as long as, basically it's not recorded and it doesn't run with the land, so, a typical listing agreement longer than a year is going to be okay. But if the listing agreement's less than a year, it could still presumably run with the land and have these other provisions as long as it's less than a year. They're trying to get rid of basically what was happening, which is you sign up 10 years ago, get a few grand, and now you're bound for, basically the rest of your life or the rest of your ownership of the property of, using this broker. Yeah, I think that's the relevant, items on this law that was passed by Alabama effective August 1, 2023. Basically prohibiting those 40-year listing agreements that we've seen, even here in Arizona plague homeowners and, our investor clients who are trying to close are having to, negotiate and deal with those things that are out there and address them.
Well, yeah, it's a problem we've been talking about for, I think, the better part of a year now. It makes you wonder, is this going to be a model for a lot of other states that are dealing with this, the Alabama law? Is it the first of its kind?
No. So there were other states that have
Okay.
previously passed. Alabama's the most recent, but, here on the West, we've seen Colorado and Utah
Okay.
who have passed. Georgia, which Brian Locker is going to be on our show today. He's licensed in Georgia.
Sure.
So they've passed that there in Georgia. So there's been, a handful of states that passed. I think we're going to see a slow progression of states hopefully addressing this and dealing with it, because it really does create problems for these unsuspecting homeowners when they go to buy and sell their properties.
Yeah, for sure. Very interesting. Well, we'll keep watching that. We'll keep watching other updates that may be associated with states trying to regulate that kind of activity. A couple updates here for the NREM podcast, a couple things for you, the listener, to take note of. A reminder, our Creative Finance Collective is every Wednesday. It's live at Wednesday at 5:00 p.m. Arizona time. So what is the collective? If you've not participated before, it's called the Creative Finance Collective, and it's designed to be just that, a membership of professionals in the space that are dealing with the subject of creative finance, mainly lawyers that are working through creative finance in other jurisdictions and approach it from different perspectives and different angles. And it's an opportunity for you, the listener, to watch, be a part of it, and to ask questions. We take questions the entire hour, and we encourage questions right from the beginning. We don't have an agenda on things to talk about. We talk about a lot of things. So we're not waiting till the end of the show to take your questions. If you have them, engage now. And oftentimes, if we've got somebody who's really inquisitive and asking good questions, we'll take multiple questions from any one person. So this is your opportunity to engage with professionals in the space, and we have a lively discussion, and it's a mix of members that are in the space transactionally, so they prepare contracts, and members who are in the space from a litigation perspective, who manage and discuss the disputes over these types of deals or other types of similar real estate deals. In fact, our guest today, which we'll introduce shortly, was on the collective just this last week discussing litigation issues involving creative finance transactions and specific performance type actions. Also, we are taking questions today. So if you have questions, don't hesitate to ask them. I'm going to turn it over to Mayu, who can give you instructions on how we're taking questions today and how you can present those.
Thank you, Andy. Happy Tuesday, everyone. It is July 25th, and you are watching the NREM podcast live. Thank you all for watching us today. If you've joined us on the show before, you do know that Andy and Sean and our guests do take questions live on the show. Wherever you're watching NREM, whether it's from Facebook or YouTube, we are monitoring the chats for your questions, and we take the last 10 to 15 minutes at the end of the show to answer them. We do take questions in order of priority, so don't wait. If you have a great question in mind related to today's topic, make sure to leave it in the comments, and we'll do our best to get to all of them at the end of the show. So that's it from me, so let's get into today's topic.
All right, thank you. With that, let's get into our topic today. We're talking about a popular topic. Well, we talk a lot about resolving title issues because as lawyers, that's often what we're hired to do. You as an investor purchase real estate, or you enter into a contract involving real estate and you attempt to close and you can't because there's a title issue. One of those can involve this idea of adverse possession and what that is. And with us to discuss adverse possession is Arizona and Georgia attorney Brian Locker. Brian, thanks so much for being with us.
Hey guys, how are you?
Doing good. We appreciate you being here. So for our listeners who may not be familiar with you, give us an idea of what you do, a little bit about your background and your practice in Arizona and Georgia.
Sure. So I'm one of the partners at Fowler St. Clair, and I've been practicing real estate and business litigation for the last 12 or 13 years. And I am currently licensed in both Arizona and Georgia. The focus of my practice is primarily in representing real estate investors in litigation that arises in the course of their business. So whether that's specific performance, like Andy just mentioned, we discussed on the collective last week, or whether it's the topic we're going to talk about today, adverse possession, which often can affect title to property and can become an issue when you go and you try to sell your property and it turns out someone else has got some sort of adverse claim to the title to your land. So happy to talk about it.
Yeah, thanks again for being here. So let's ask the question that everybody who's watching really cares about. If I move to the rolling hills of Georgia and the beautiful suburbs outside of Atlanta, and I move next to you as your neighbor, can I utilize your property and take it as my own?
Hypothetically, yes, if I don't catch you first.
I'm cashing in my frequent flyer miles now. I'll be that. So let's get into that. Hypothetically, yes, I know as a good lawyer, that means a whole different uh, contingencies to that answer, right? So let's talk about this. We're talking about adverse possession. What is adverse possession?
So adverse possession at its heart is simply the use of property that is not your own for a particular period of time and in a particular manner, right? So there's a number of different qualifications that you need to meet in order to be qualified as an adverse possessor, right? So if you're the one who is actually using someone else's land, you can't just, you know, put up a stake on someone's property, wait 20 years or 10 years or whatever the statutory time period is, and then go down to the courthouse and say it's mine, right? Your use has to be of a nature that is consistent with the kind of property that you are adversely possessing. You need to do it for a particular period of time, and it needs to actually be adverse, right? And I know we'll get into some of those issues, but at its heart, adverse possession is the use of someone else's land for the requisite period of time that allows you then to go and claim ownership in that land, whether full-blown ownership or the use of that land in the way that you were using it before, even if you don't get to own it.
I think one thing that comes as a shock to a lot of people who aren't familiar with it, this idea that you can take land that maybe you didn't pay for or whatever else. But I usually try to encourage people to think about adverse possession in the context of history. You know, adverse possession is, as with much of the law of the United States, is inherited law, the common laws that came to us from our ancestors who really came over from Europe and England. And, you know, I think the idea and the concept with real property law was this idea of use and cultivation and utilizing it. You see this in like states that have had like homesteading laws and things like that, which were probably a lot of the states early on. This idea that, hey, you go work the land, you go, you know, make it productive, and it's yours. And I think that kind of rings true in the concept of the law of adverse possession today. Do you agree?
Sure. Yeah. I mean, I think the idea is if land has effectively been abandoned, and the statute, an individual state statute is going to determine what qualifies, the length of time that qualifies for abandonment. But if you've abandoned your property and allowed someone else to use it, then after a certain period of time, again, you know, like you said, dating back to the common law, after a certain period of time, it's deemed to be yours. You need to defend your property.
Now, adverse possession doesn't have to take on a particular form, right? So some people might be thinking, well, okay, so what does this mean? I move into somebody's house, I take it over, I build a wall, and the property's mine. I mean, it certainly could mean that, but it doesn't necessarily have to mean you're taking over a property in its entirety.
No, in fact, usually that's not the case, right? Usually it is the case that it is a portion of land. And we see that most often in like boundary disputes, right? For instance, this just came up with my neighbor about a month ago. We had a new neighbor move in, and he wanted to build a fence around his backyard. It had not been fenced before. And so he actually had a surveyor come out and pin out the lot lines. And it turns out that my fence was on his land by about 2 feet. And so he let me know, he's like, hey, you know, just so you know, your fence is on my property. And I was like, well, it's my property now, but because that fence was super old. But so those kinds of things happen all the time, right? Builders are human. And so when properties get developed, you know, there's you know, whoever the fence company was that put up the fence or whatever just didn't measure correctly or whatever. And then you've got your fence on someone else's land, and it's inadvertent. But that's often how we see that see that manifest is some sort of inadvertent act that just kind of stayed that way for a very long time.
Hey, Brian, talk to us a little bit about, I mean, we're talking about residential properties or maybe commercial and, boundary disputes and things like that.
Mm-hmm.
But let's talk about too, like adverse possession can be used for, say, easements or access to property and roads and things like that, that maybe never really exist, but people just, like decided, well, I'm going to drive across this strip of my neighbor's property to access mine. So they're not possessing it except to the extent they use it, a couple times a day to drive to or from their house. Talk to us about what that looks like as far as roads and access and easements.
Yeah, we see that on a fairly regular basis too. And that takes usually two forms are the most common, right? One is access by way of necessity, right? So there may not be a road there to access a particular parcel of land. That can happen when you have a larger tract of land that is subdivided. And for whatever reason, the county or the owner didn't catch the fact that one of those subdivided parcels is going to be orphaned and not have actual access. And so you can have an easement created just by the use of, land that may not have any particular road, and it's just used over time. And so that's one way. And then the other way is where you actually have like a hostile use, right? So okay, my property has access over, on the west side of the parcel, but there's this really convenient road over here, and and a driveway or something, and I'm just going to kind of skate over on the eastern side and get to my property that way, and nobody said anything, and so you get it not because you need it, but because it's convenient and you do it for long enough.
So, Brian, we've been talking about the requirements or kind of dancing around some of the statutory requirements for establishing adverse possession. And we've talked a number of times, well, you brought up a number of times, an adequate time frame. Mm-hmm. Let's talk about kind of the elements of adverse possession. And when you say time frame, what are we talking about? And I know that can mean different things in different jurisdictions, but why don't you talk to the jurisdictions, Arizona and Georgia?
Sure. So the primary elements of adverse possession are use, right? And so basically using the land in the way that that a person would use that particular type of land. So that can be different depending on the kind of land that we're talking about, but you need to actually use it. It may not need to be consistent, use or continue. It doesn't necessarily have to be continuous use. Again, depending on the kind of land that we're talking about, but it needs to be used. And then it needs to be hostile, right? So it needs to be against the interest of the person who actually owns that land. It needs to be for the requisite period of time. And so in Georgia, that's 20 years. In Arizona, that's 10 years. I think that, generally speaking, sort of gives you the range of different time frames that you're going to get, right? States are going to probably fall somewhere in between those. 10 years for Arizona, 20 years for Georgia, and then yeah, and it need and so those are the main main elements that become issues in our litigation.
Sure. I would imagine it's interesting. I wasn't an attorney prior to the internet age, which really kind of began, I guess, in full thrust in the 90s.
Yeah.
But adverse possession, the law hasn't changed a whole lot. And the statutory time prescriptions and requirements haven't really changed probably at all for decades and decades, probably centuries.
Yeah.
But I would imagine pre-internet, establishing a claim for adverse possession for that period of time was pretty difficult, and maybe proving the facts to do that. I think it's getting a lot easier with things like satellite imagery and the ease and the ability to access county assessors records that are providing for free satellite imagery. I think of times where I've represented individuals on adverse possession where it's like, one key indicator early on, was there a road going across your property? Okay, that's going to be a problem. Nowadays, the internet's been around long enough and satellite imagery's around long enough. It's not hard to go look at a property 10 years back. And if that road's going across, it's probably, you've probably gone along a lot of the way you need to do to prove that case. Are you finding that technology has made it easier in that regard to prove cases for adverse possession?
Oh, 100. Well, so I should preface this by saying in the Valley, so in the greater Phoenix metropolitan area, in Tucson,
like Maricopa County,
Pima County, absolutely, yes, because we don't have forestry, right? And so you can get your aerial shot and you can see often all four corners of a particular parcel, right? When I moved to Georgia and started practicing out there and we had an adverse possession issue come up, I went and grabbed satellite imagery. We got trees everywhere.
All you see is branches.
Right? Yeah. So, I mean, boundary disputes are not going to be resolved with satellite imagery in a place like Georgia or even northern Arizona, right? Where you've got a lot of forestry. So it depends. But yes, I mean, to your point, we had an issue not too long ago, about a year or so ago. And the issue was whether a particular part of a commercial property had been blocked off, right, and sort of siloed off. It was a parking lot, and the issue was, all right, did they sort of reserve these parts of the parking lot for their own use? And we were able to show through satellite imagery, you could see where they had put a big chain link, just a chain across two posts, and in the satellite imagery you could actually see the shadow being cast onto the ground of that chain link, and we could establish, and you could see that it went all the way back more than 10 years, and so that was by and large dispositive of that issue. So it absolutely can essentially resolve the use issue, right? Do we actually have the use for, or the, whatever the physical intervention onto that property? Does it actually go back 10 years? And oftentimes the satellite imagery will resolve that particular issue. And so you're only left with the remaining, the remaining elements of adverse possession.
Now you mentioned the elements of adverse and hostile, and just thinking of this and approaching this from a non-lawyer perspective, my initial thought is that sounds violent. That sounds like Hatfield and McCoy type property owner, like warfare. That's not really what the elements mean, though, right?
No. I mean, hostile simply means against another landowner's interests, right? And so that could be something as simple as utilizing a driveway on the back of someone else's property to get to your property, right? I mean, it's not inherently hostile like in the way that you're describing Hatfield and McCoy's. And oftentimes it can actually be inadvertent, right? The person doesn't even realize that he's driving over your property, but as long as you intend to drive wherever you're driving, then that would qualify as hostile, even if you don't have the present knowledge of the fact that that use is, in fact, over another person's property.
So in describing the different time periods in order to establish adverse possession in the states of Arizona and Georgia, there was a difference between third parties and color of title time periods. Can you explain what that difference is, what that means?
So one of the ways to reduce the amount of time that you have to wait in order to qualify for adverse possession is that you can take the property under color of title. And all that means is that you've recorded something in the county in which the property is located that makes it overt that you are claiming an ownership interest in that property. And so that could be, it could take the form of a deed. It could take the form of an easement. Whatever it is, you're recording something with that county that puts the entire public on notice that, hey, I am claiming an interest in this particular property. And what that has the effect of doing is reducing the overall amount of time. So in a place like Georgia, I believe it takes you from 20 to 7 years. I'll refer to my notes here in a moment. And then in Arizona, I think it takes you from 10 to 5.
That's right.
But in any event, it drastically reduces the amount of time you have to wait, with the idea being that if you are a landowner and you are properly caring for your land, you will find these issues of record that are presumably more obvious than something an actual physical use of the property. So they'll actually, the law allows you to accelerate that process.
Brian, I want to jump in though, just to clarify on the color of title. You have to have a good faith basis for whatever you're recording. Meaning you can't just go and say, I'm going to reduce the statute by 5 years because I'm going to march down knowing that I don't have any interest in this person's property. I'm going to, wrongfully record a document against their land. I mean, you can't do that. You have to have some good faith basis to be, like, hey, I should be the owner of this for various reasons. One common example, and we'll talk about this, how to clear these issues up later and how to use adverse possession to clear them up. But one common example would be, hey, I've inherited the property, but there was a title defect early on, which actually put the property in somebody else's name. But, it ended up going to me by inheritance, or at least I had a good faith basis to believe I inherited it. And so I now have this deed to the property, but in reality, I truly didn't own it. But if I use it for 5 years and I pay the taxes on it for 5 years and I have color of title, a recorded interest that is in good faith, appears to be an interest in my favor, then I can do it. But I can't just be like, hey, I see that vacant house over there. I'm going to go wrongfully record some document when I know I have no interest in it, and then now reduce my, adverse possession rights to, half the time.
Sean, are you saying that a sovereign citizen is not a good faith basis?
Exactly. Yeah, we've seen
we actually had this issue come up very recently. There was a property out in rural Arizona, and our client owned, there was like 3 parcels nearby to each other. And he was just sitting on them. I think he acquired them back 8-9 years ago, and was just kind of sitting on. There were these structures, sort of shanties on them. They weren't being occupied or anything, but he was going to go and improve them and sell them. And it turns out some hostile entity with an anonymous LLC out of New Mexico had just out of the blue conveyed all 3 of his properties into this LLC. And I have to imagine the idea being that he was going to try to claim adverse possession by color of title. And I had this conversation with an attorney for that county. And I was like, I think they're trying to get this by adverse possession. And he's like, can you get property by fraudulently conveying it into your name? And I was like, no. So it wouldn't have worked anyways, but it did create this title issue. And because it was an anonymous LLC, it's not like we had some person to go after for damages. So it created a complete headache for our client to clean it up after the fact.
So let's talk about title issues that can be created by or resolved through adverse possession. And I guess some of this is a little bit of a discussion on knowing what to look for as an investor who's buying property, and what is invariably going to become potentially a title issue. I think a common one is encroachments, things that aren't on first glance, uh, looking at the property, apparent, but maybe with a walk around, they do become apparent. And I think that's really interesting. I'm really glad we went into the satellite imagery. I didn't really have an appreciation until you mentioned it, that a lot of these things you can't see with a heavily wooded area. You know, in Arizona, like you mentioned, in Maricopa County, I can see if the lot adjacent to the lot I'm looking at, if the horse shed skips over the line by a foot, that's
Yep.
usually evident in just a quick satellite imagery. But what kind of in what ways do encroachments create title issues, and what ways have you seen them create those?
Sure. People not respecting setbacks, and so they build structures right on property lines. That happens all the time. Sheds, right? The idea is, hey, I'm just going to build a shed in the corner of my property, and the homeowner doesn't really pay attention or get a survey done, and so bam, you've got an encroachment issue. Now that may or may not, depending on the property, may or may not be material, but yeah, I mean, it's something to be cognizant of. I mean, more than anything else, it's important to be able to issue spot these things, right? At least be able to ask the question, hey, is this going to be a problem? And asking, a knowledgeable professional, hey, is this going to create a problem when I have to go and resell the property, or, what have you? Because sometimes, there might be a survey requirement through a lender or what have you that wouldn't have been caught on your transaction to acquire the property, but would get caught on an end buyer type transaction. And so, issue spotting is really the key, and then, getting it figured out prior to acquiring the property, instead of acquiring it and then realizing you've got an issue, when you can no longer negotiate with the seller.
There's here in Maricopa County, I know of a title company who, because like you guys mentioned, technology has now, as part of their title examination, they will actually go onto the assessor's website and pull the GIS map and look for encroachments, both
Sure.
the property that's being sold. They'll look to see if there's anything on that property that's encroaching on the neighbor's property, or whether or not there's anything on the neighbor's property encroaching on that property, and then they will list
Accept
it
it out.
as an exception to the policy.
Yeah.
And so, I've had at least one matter where I was consulted because the buyer didn't like that, because they found, on 3 of the 4 sides of the property, they found encroachments,
Yeah.
because it was an older property. And like you said, Brian, like, they just built the fence where they thought the property line was. They didn't want to spend $2,500 for a surveyor to get the fence, exactly like spot on. And
Yeah.
so, one of them was my client's fence was, on the neighbor's property, and the other 2 were, the neighbor's fences were on my client's property, and the buyers did not like that. And they're like, we don't want to buy. And so they wanted to back out. So, it was one of those things like, well, what are our options here? One is you find another buyer who kind of understands, hey, it's, in my view, it's not a huge issue unless it's, a real significant thing,
Yeah.
or, in the case where your fence is on their property, we went and did the look back with the GIS maps. I'm like, well, it's been here over 10 years. You could bring an adverse possession claim and get your strip, and then you could go to your neighbors and basically just give them title to the couple of feet that, it's on your property, and just clean it up, basically clean up the legal description to your property.
Mhm.
And so, those are kind of the options, but that's one way on these encroachments. You can clear this stuff up through adverse possession is, you can just go and adversely possess, that strip of land that your fence was accidentally built on. And then, or you can even go to your neighbor, instead of making them adversely possessed, just let them have it. Because, the risk or the concern to me on the encroachment thing is, and it's a small risk, but if somebody's built their fence on my property, right? And, you know, let's just say they have somebody there on their property doing work or something like that, and they somehow get injured on that 3 or 4 or 5 foot strip. Technically, they probably have a claim against me, despite the fact that it wasn't on my side of the fence, right? So
Yeah.
that's, to me, I think most people's biggest concern is like somebody else is using my property and I have the liability for it potentially, right? So, you can resolve that by just being like, hey, you can have a couple of feet, like
Mhm.
take it, or, a license, but you have to insure it and, make sure that I'm named, or as an additional insured as to that strip or whatever. But,
Yeah.
so those are ways in my view, or what I've seen as far as these encroachments, that you can go kind of approach it and deal with them.
Yeah, and look, the bottom line is these kinds of encroachments, the most common ones in these single family neighborhoods are not a big deal. It's more of just it's just a cost issue, right?
Mhm.
By and large, they'll be resolved either by some sort of an easement agreement if the 10 years or 20 years hasn't passed, right? You just enter into an agreement with the neighbor saying neither of us have to do anything. Or if it has been 10 years, going through the process of securing your title, that means you got to bring a legal action. Maybe the neighbor cares, maybe they don't. If they don't care, then you can just go get a stipulated judgment. But then you're gonna have to go get the property surveyed, so you get a new legal description that includes the adversely possessed property. Then you got to go register it, with your county, and it's you're going to spend thousands of dollars, and so it's more of a hassle than it is an actual legal battle most of the time.
So you're an investor, you come in and you buy the property, and the title report shows that there is an encroachment. And you do a little bit of investigation, and it looks like that encroachment's been there for, let's say, 9.5 years.
Mhm.
You're like, okay, it hasn't been 10 years.
Mhm.
I love this property. It's a good price. I'm gonna have to deal with these folks.
Mhm.
But adverse possession has to be hostile and adverse, and there's defenses to it. What can I do if I want to come in there and stop that 10 years from running?
So immediately, immediately cease the use, right? So that could take a number of different forms. But if you realize, if you're the neighboring landowner, and you realize that there's been an encroachment for an extended period of time, then I would it depends on how close you are, right? If you've got 6 months, then you would probably start out with some kind of a letter to your
Now
neighbor.
I can theoretically just give them permission to do it, right? Does that me giving them permission and consent,
Mm-hmm.
does that stop hostile and adverse use? I think that it does.
Well, sure. So yeah,
The
a
question is
defense,
documenting that,
right?
probably.
Yeah. So a defense to the hostile element of adverse possession is permission, right? So if you've granted permission for the use, then that would toll any adverse possession claim. So it really depends on what the encroachment is, what the possession issue is, and whether you actually want to do something about it as the person being adversely possessed.
Where
So-
I saw this done, I represented a client who built a wall. And to save every investor of money, right here, 30 seconds is going to save you all the money in the world here. When you go to the property you just bought and you decide to put in a wall and there's a stake just sitting out there, don't assume that's the corner and just build $30,000 worth of wall based on some stake, because it's probably going to be wrong. So that's why you get a survey and everything else. But this homeowner built a wall and it went all over the place onto the other person's property. They didn't even know that until they wanted to do their own construction project.
Mm.
And they went out and got a survey. And what did they find? They found that there was a wall on their property. So they went and got a lawyer. Now they happened to like the wall. They didn't want to tear it down, but they didn't want to lose their property due to a claim of adverse possession. So the lawyer's like, well, you need to document some form of permission. In that case, we negotiated, and my client entered into a license agreement that was recorded against the property, and that allowed the wall to stay. But jumping forward a few years, here's where this gets dicey. License agreements are permission slips, and contractually, we had to agree to this, but contractually, they have built-in provisions that allow the cancellation and termination of the permission at some point, maybe with notice if you negotiate some form of notice. And sure enough, my client eventually decided to sell the home. And his homeowner was like, I enjoyed having a license agreement with you, but I don't know who you're selling this to. So I'm giving you notice that that we're canceling the license agreement. And suddenly you're listing your house for sale, and you've just been given notice that you're canceling your license agreement's terminating.
Yeah.
And suddenly realizing you're going to have to tear down, 100 feet worth of wall and reconstruct it and notify any potential buyers. So that is why that's one fix by giving permission, but it certainly doesn't solve. Just go get a survey and make sure it's done right. You don't run into this problem to begin with. So let's talk about, you've run into an adverse possession claim. What do you need to do to resolve this in the courts? Because you have a claim, and maybe you've been using somebody else's property for the requisite statutory period of time, 10 years, 20 years, whatever the state may be.
Yeah.
But it could be 100 years, and the deed is still going to show that other property owner. How do you resolve that issue and essentially solidify your claim that you've maintained through adverse possession?
Yeah, so that's it's through an action called quiet title, and the idea of a quiet title claim is that there is a dispute over the ownership, presumably a dispute over the ownership of the land, and you are asking the court to resolve that dispute and make findings of fact regarding your use. Presumably, you as the adverse possessor are the one who would be bringing the action. That's the most common scenario. And so you're asking the court to acknowledge as a matter of law that section of property that you've been using or adversely possessing is now yours. And assuming then you are successful in that action, and if it's contested, then you would need to win at some sort of a evidentiary hearing, and if it goes by default, then you'll get a judgment without too much trouble. But then you're able to take that judgment that will presumably include a legal description of your new property, and you can go record that judgment and update the records with the county.
Brian, I know in Arizona, if prior to filing a quiet title action, you generally want to send a demand letter along with some other stuff out to preserve your right to attorney's fees. Talk about that and what that looks like and how long you have to wait, and what exactly needs to be sent.
Yeah, so in Arizona, Arizona has decided to create a statute called ARS 121103 that allows someone who is claiming an interest in property to send out a letter giving the opposing side an opportunity to simply give you the land without filing a lawsuit. The idea being that we don't want to crowd the courts with a bunch of claims where there may not be real legal disputes. And so if the opposing party simply signs a quitclaim deed that you provide them within 20 days, then it resolves the issue, and you don't have to go to court. Alternatively, if they don't sign the quitclaim deed that you provide them and you have to go to court and you win, then Arizona will grant you attorney's fees. And so it's a really good tool for us that we can use in these quiet title cases, often for adverse possession, but it can, other title issues. You can use this statute as well. Georgia doesn't have one of these quiet title statutes, and so you really, it's going to be on a state by state basis whether that's an option that you have. But it's a good thing to be aware of and see if that's an option for you.
And then after you file, or in conjunction with filing the lawsuit, anytime you file a lawsuit involving real property, you should record a notice of lis pendens. So talk to us about that. What does that, do? What does that look like? What's the purpose?
Yeah. So when you file a lawsuit that involves title to real property, then you can actually file with the court and then record in the county where the property is located a notice of lis pendens. And all it is a simply notice to the public that there is some kind of dispute regarding title to this property. And so if the person who owns the property that's in dispute tries to go and sell the property while this dispute is pending, then a title company will catch it and basically tell the seller, hey, you need to resolve this before you can give clear title, because the title's in dispute.
And then finally, talk to us about the timeframes. All of a sudden, I have this adverse possession claim. I'm trying to sell my property. I'm trying to, make sure I have access to my property. I'm trying to do all these things to clear up, these issues. What am I looking at on timeframes? Obviously, I want the demand letter to go out because I want my attorney's fees. And so you have a demand letter and then a lawsuit and a lis pendens and, all of this stuff. What would somebody who wants to try to clear up their title through adverse possession be looking at as far as the timeframes go to resolve all of this through the court system?
Yeah, timeframes are often, especially for a real estate investor, right, where they often are going to be leveraging the property with hard money, and so for every day that you have that property, you're paying interest, and so a lot of times we forego the 20-day notice simply because it's not worth the additional expense of waiting the 20 days. But yeah, so the timeframes. I always say for litigation, because you really don't know often a couple of things. One, you don't know whether you're going to be able to quickly serve the defendant. Now, if it's a neighbor dispute, right, you're likely going to be able to serve the defendant if your neighbor lives in their home, right? So that's not going to be a problem. But you don't always know whether the issue is going to be contested. Right. And so what I tell people often is, look, best case scenario is we can serve the person immediately and they don't care to fight it. Then you're looking at probably from the moment we serve that defendant until you get a judgment that clears title, you're probably looking at somewhere between 60 and 90 days. That's like best possible case scenario, where the other side just lets the thing go by default, and you wait out your 20 days for service, you file for default, you get a court date, and you get your judgment, and that all happens about 90 days, because the court, once it gets word of default, often will set a hearing in the next 30 days following the default. So that's not always a hard and fast rule, but we find that most times cases going by default end up in that time frame. And then if it's contested, if there's an actual issue of fact over the use of the property, over the timeline, there's any number of issues in an adverse possession claim and I just tell people, sky's the limit. Now hopefully we resolve them early. And most of these cases get resolved early, but you just don't know. It could be 90 days. It could be 6 months. It could be 2 years. You really don't know, which is why it's so essential. We were talking about earlier, just being able to issue spot that, and to be able to ask the question prior to purchasing the property, so that we can sort of talk through those risk factors that could add substantial time to the amount of the length of time that you're going to have to own this property if it's going to be a fix and flip or something like that. So super important. And then one thing that I thought of after we sort of talked about it, there are a lot of states that have implemented programs that allow you to monitor the title status of your property. So Georgia in particular has a program where you can go on to the Georgia Secretary of State's website, and you can sign up as the owner of your property. And if anything that affects title to your property is recorded, you get a notice by email and by text message. And that's becoming more common throughout the United States. So I would say if, even if you're not a real estate investor, but you own property, you should check your state and see if a similar program has been implemented.
Well, then let me ask you this. I mean, I sign up for this program, and all of a sudden, a year down the line, I find out that some New Mexico LLC has tried to convey my property to itself. What do I do?
You call a lawyer.
Quickly, right? I mean, you don't want it
yeah.
to stay out there. I mean, you want to
No.
get it wrapped up as soon as possible.
Real estate fraud's a real thing. Just because they don't have a valid claim to your title doesn't mean they can't do all sorts of terrible things in the process of conveying it out of your name, right? The biggest issue we find in real estate fraud is they go and leverage your property. If you have a paid off property, it could be vacant land, it could be whatever, and they combine the real estate fraud, so taking the real estate out of your name and putting it in their name, they combine that potentially with identity theft. They can go and take out loans against the property, and often, depending on the situation, you may be stuck paying those loans back.
A savvy criminal isn't after your property. They know if they sit on title long enough, they get caught. It's a matter of public record, and they don't care. They're after the loan proceeds that they can use to by offering your property as collateral to a lender. Once they get the loan proceeds, they're gone. They don't care. And now it's between you and the bank to work through that. So that very interesting. Well, Brian, thanks so much for being with us. Tell our listeners how they can find and connect with you.
Yeah, absolutely. You can find me on fowlerstclair.com, and you click through the attorney's link at the top. You can schedule a time to meet with me if you're a real estate investor and have questions about buying and selling real estate and litigation and anything like that. I'd be happy to chat.
Well, again, we appreciate you being with us and look forward to doing it with you again, Brian.
All right. Thanks, guys.
Have a good one.
Thanks, Brian.
With that, everybody, that is our show. Thanks for joining us. Make sure to join us next week. We'll see you then.
Have a good day, everyone.